Good to go.
Yes, Naman.
Okay. A very, very good evening to all. Happy Constitution Day. Samvidhan Divas ki bahut bahut badhai. I welcome you all for this unique seminar organized by Jaipur Chartered Accountant Group. For those who are unaware about JCAG, it was just to brief you about the history of JCAG. It was started in 2012 by some group of professional friends who wanted to discuss technicalities and non-technical things on a fortnightly basis. Sometime later, then we started with few public programs, which is like these programs. Earlier, it used to be done in a physical manner, but now with the convenience of technology, we can do it on an online mode. So, and we have done a very novel programs like Budgetonomics, Brain Trust, and CA Firm of the Future. So as to bring new and novel topics every time. And in that chain of thoughts, we today have a session on constitution, which is often, I would say, often neglected, but yet very important, because these days we have seen all the practices are developing, all the laws are developing based on the form. And when laws are developing based on the forms which are developed by IT cells of various departments, then it's very, very important to know what is the constitution, what is the legal standing, and how we can challenge this up. Before we just start, I want to give some important facets about our constitution. This original 1950 constitution is actually in a nitrogen-filled case at New Delhi Parliament. So this is kept in the still, and somebody who go to the Parliament can actually see that. Ours is the longest constitution for sovereign nation. It contains about 1.46 lakh words. So can you imagine 1.46 lakhs word? So I feel that now our many tax acts and coupled with circulars with amendments would take over. The initial constitution also had around 2,000 amendments in this first draft itself. So first draft itself, when it was presented, had 2,000 amendments, and the whole process took 2 years and some 11 months and 18 days to complete. So it's really, really interesting, some facets about our constitution. I welcome you all once again for this very, very interesting seminar. We have with us Advocate CA Jatin Harjai, who is not just, I will say a law freak, but also, always mentors people, always guides people. And that's my informal introduction. And before I cordially invite Jatin Bhaiya to speak, I would request Shefali to give a formal introduction of Advocate CA Jatin Harjai.
Thank you, Naman sir. Thank you and happy Constitution Day to everybody. I'm glad that I'm introducing one of my favorite speakers, Mr. Jatin Harjai. So he's a practicing advocate. Earlier, he was practicing for 15 years as a CA. And he has in a very short span of time, he has become recognized for his contribution and expertise as a knowledgeable professional advisor and consultant in the field of financial consultancy, tax, and advisory. He has been guest faculty on various educational, professional, and institutional platforms, shared his views on VAT, CST, entry tax, work tax, GST, and many more. As a matter of GST awareness and preparedness, before and after implementation of the biggest Indian tax reform, he has vastly addressed to professionals, industry, and government officers. He has addressed more than 750 seminars, workshops as faculty, speaker on indirect taxes in almost all regions of India. Apart from India, he shared his knowledge in international seminars, workshops at UAE, Thailand, Tashkent. He authored many articles on indirect taxes, which were published in leading tax journals and contributed in many publications of ICI on GST and UAE VAT. So Mr. Harjai is actively engaged in representing industry before department at various levels. He has represented in the Tax Advisory Committee before Chief Minister of Rajasthan for giving recommendations and suggestions before state budgets. Apart from TAC, he has represented Institute of Chartered Accountants of India, Rajasthan Tax Consultants Association, Tax Consultants Association Jaipur before Commercial Taxes Department and various levels in relation to modification in VAT laws of the state and development of GST. That's a lot, Jatin sir. So we welcome you all. The mic is over to you. You may proceed. I request everybody else to keep their mics on short. Mute.
Should I?
Yes, sir.
Thank you, Shefali, for the lengthy introduction. I was expecting to interrupt you in between that. Okay, we can start. Anyhow, and Naman, Yash, Kshat, Vishnu, Yash, and all others who are there on the this part as a participants, maybe you on YouTube or on the Zoom. I must say very good afternoon to all of you, and I must say happy Constitution Day. The moment this date comes, see what happens. जो मेरे साथ होता था वही मैं आपके साथ explain करना चाहता हूँ. The moment this Constitution Day comes, first questions comes in mind: why this day? Because we are already having a Independence Day, isn't it enough? Apart from Independence Day, we were having a Republic Day. So independence, we can understand, we got independence. Republic Day, okay. The Constitution was enacted on 26 January 1950. So what is this Constitution Day? Normally we, as a tax fraternity people, we normally talk about taxes. Today I would like to give a talk on the mix of what actually has happened, maybe a bit of history, maybe a bit of other principles which are there in the Constitution, and yes, obviously taxes. Otherwise, you won't spare me. So I will try to mix everything. First of all, let us start with what is the importance of this day, from where it comes. As Naman has rightly said, our Constitution, drafting of our Constitution took approximately 3 years, 2 years, 11 months, and some odd days. Precisely, Constituent Assembly was given the task to draft the Constitution in 1946 itself. And first meeting of the drafting committee held on, if I'm not wrong, 9th December 1946. From there, work started. And first draft was completed in early 1948 itself. First draft of our Constitution. It was completed in somewhere January or February 1948. Thereafter, each and every aspect was discussed in great detail in the Constituent Assembly. And Naman, as Naman has rightly said, more than 2,000 amendments in that draft was carried out. Then we got a final draft and recommended by the committee, which was adopted as a final Constitution of India on 26 November 1949. It was finalized and adopted even by the Constituent Assembly on the 26th November. That is why it is called a Constitution Day. Now, why it was not immediately implemented or enacted? We have waited for 2 months, 26 January. It has a historical significance. See what happened when we were having a British rule. Different type of agitations were going on. Though everyone was fighting for independence, but maybe their thoughts were not always in a same fashion. And we all know that British not only ruled India, they ruled most of the world. And by that time, different countries got independence from them. So at that point of time, if we talk about what were the recent countries, recent past, which was there, which the countries which got independence from the British were like Canada, Australia, New Zealand, South Africa. Those were the countries which got independence. And they were having a same model. These all countries were having a same model, which is called as independent dominant status. That means there will be a government which is elected by you people. That means you people who are sitting there. But ultimately and final authority shall be British Crown. That means again it will be a kind of colonial rule. Just like you can say most of the things you will handle on your own, but ultimately supremacy will be there with the British Crown. For likely we can understand, like in our constitution, president has very little to do and very rarely has to do something. So in that kind of situation, that presidentship, we can say, understand like this, कि president wahi ka hoga, rest everything will be with you. So with that thought process in late 1920s, this thing came up that India can also get independence very soon on that same model. There were different persons, like Nehru ji ke father sahab kya naam tha, Motilal Nehru ji. They were of the opinion that yes, dominant status independence is good enough for India as of now. At least wo to mile. In fact, Gandhi ji was given a assent that okay, 2 साल के अंदर आप हमें status दो, independence दो, let it be in the dominant status. But finally इसके ऊपर एक बहुत लंबा discussion, विचार विमर्श हुआ. There was a famous Congress अधिवेशन in 1929. इसमें बाकायदा जिसके ऊपर वोट हुआ कि whether independent dominant status is acceptable to these people or not. Finally, after voting, it comes out that no, we don't want dominant status at all. We want complete independence, जिसको कि नाम दिया गया पूर्ण स्वराज. We must have heard this word, पूर्ण स्वराज. So वहां से ये संकल्पना निकल के आई कि हमें जो चाहिए, we don't want any kind of interference from the British. Leaders at that time for this particular thought was Jawaharlal Nehru, Subhash Chandra Bose, and Dr. Keshav Baliram Hedgewar. So these were the persons who led this movement, and finally on 31st December 1929 itself, they hosted the flag in Lahore itself. And at that time it was declared that we will celebrate 26th January as an Independence Day. Please mind, Independence Day, not Republic Day or Constitution Day kind of thing, because it was not there at that point of time. So as a mark of their own revolution, they said, okay, we will celebrate 26th January, and 26th January was celebrated in first time in 1930 as an Independence Day all over the country. Keeping that tradition in mind, it was proposed in Constituent Assembly that we will keep the significance of 26th January relevant. That is why this 26th January 1950, the Constitution of India, which is the largest constitution, has been adopted. So this is what whole of the, I can say, brief history. Otherwise, so many integrities were there. Now, what is a constitution? See, we can say a written set of rules by which we govern a particular entry or maybe entity or a country or for whatever the constitution is being made. Just like a partnership deed is for a partnership firm. A memorandum articles for a company. For a country, it is a Constitution of India. For a country like ours, it is a Constitution of India, which is actually run on the basis of this Constitution. The moment we start reading Constitution, believe me, you will start admiring more and more. The moment you start reading debates of the Constituent Assembly, you will see what kind of brilliant thought process, what kind of brilliant arguments were there from the each and every side, and the decisions were taken at that particular point of time. That is why there were 2000 amendments in the fixed structure which was there. Now, if we compare it with any other leading constitutions which are having in the other countries, if I compare it with the Constitution of United States, around a year ago, we were having this kind of discussion. Then I witnessed and I gone through with the United States Constitution, and I was surprised to see whole of the Constitution along with all amendments were completed in 19 pages. Total 7 articles are there in the Constitution of United States. By this aspect only, you can understand, one can understand or imagine that what a great thought, detailed thoughts has been given while drafting the Constitution. If I come to analogy, what is analogy behind any constitution, or whenever or you are reading the Constitution? See, prima facie, or I would say primarily, Constitution provides a boundary, exterior boundary for the government. The way how I understand the Constitution, I'm just sharing it with you. It provides exterior boundary, or you can say maximum government has a right to do. And on the contrary, for the citizens, minimum rights are being provided to the citizens, meaning thereby, if Constitution provides that the government can do this thing, maximum can do this thing, then government has an option to do that thing or not to do that thing, but they cannot go beyond it. Simultaneously, if I talk from the citizen point of view, minimums are provided, fundamental rights, other rights apart from fundamental rights, like right to property, 300A. All these are the minimum rights which are guaranteed by the Constitution to the citizen. This is minimum. If the ruler wants to provide something else, something extra, they can definitely provide so. They are more than welcome to provide additional rights. But there is a minimum level, which we all know what fundamental rights starting from Article 14 onwards, which provides for. So that is minimum. If I talk something about just a general talks about our Constitution, we have seen that so many times people say that a particular document like a Constitution should be flexible enough. And at times it is being said that it has to be rigid enough. So if we compare with the others, or we analyze our own Constitution, is it a very rigid document? Is it a Constitution which doesn't provide any flexibility? Is it so? Or it is very, very flexible? See, whenever we read these constitutional papers, in the law there is an exam separately. There is a most common question is this one: what is the nature of Indian Constitution? Is it rigid or is it flexible? An answer lies again, the catchy answer is it's both. It's rigid as well as flexible enough. We have seen that more than 100 amendments has been carried out after 1950, after adoption of the Constitution. Rigidity or flexibility of any document is judged by how easily an amendment can be done in the particular document. If I talk about this, our Indian Constitution, Precisely, Article 368 provides for how our constitution can be amended. In normal circumstances, it provides that with a special majority, the constitution, special majority in the parliament, it can be amended. Both houses of the parliament, Lok Sabha, Rajya Sabha. Once it is passed by a special majority of both the houses, then it shall be given for the assent to the president for its assent. Special majority means 2/3 of the members present in voting and minimum 50% of the total number of the house. This is what special. Now, if we see, at times it looks like, okay, क्या सिर्फ पार्लियामेंट ने ही अपनी तरफ से पास कर दिया, इसमें तो स्टेट्स का कोई रोल ही नहीं रहा. There may be a thought on this कि स्टेट्स का क्या रोल रहा है इसमें. Only and only parliament change this thing. See what happens, जबकि कॉन्स्टिट्यूशन लगता सबके ऊपर है. We are having parliament, 2 houses in parliament, Lok Sabha, and then there is a Rajya Sabha. The members of the Rajya Sabha are basically appointed by the votes of state legislatures, that is MLAs. Meaning thereby, it is a forum whereby the representation of its states are there. So in true sense, central as well as states consents are there, maybe directly or indirectly, in either kind of amendment, if these kind of amendments gets through. But what is more important is, whenever there is a special kind of things, Article 368 specifically provides, whenever there are specific amendments which hampers right of the states as well, or maybe representation of the state, certain specific clauses, 5 clauses are provided, including the amendment in Article 368. That means provision through which amendment gets in place in the Constitution. So if these kind of provisions are to be amended, in that case, apart from the special resolution in the both houses of the parliament, before these bills are getting presented before the president, it is necessary that 50% of the state has to consent to it. State means the state legislature here. That means Lok Sabha, Rajya Sabha में पास हुआ, और उसके बाद 50% of the states का भी consent आना necessary है. Without this, amendment cannot through. In respect of those articles, which is getting actually difficult thing. But that is all about changing or maybe altering something which are fundamental in the Constitution. That is maybe hampering the right of the state. In those all places, these kind of rigid conditions are there. So if we go by these analogies, we can say this: we are having a rigid as well as flexible. Wherever required, accordingly, we are having a brilliant constitution on these particular aspects. One more aspect before I come to some of the taxation aspect or maybe something which are in relation to professionals. One last thing is I'm also having in my mind, which I want to touch upon. When I'm discussing amendments, see, there is a landmark judgment of the Honorable Supreme Court, Keshwanand Bharati. I'm sure each and every one of you must have heard about it. So many things were there. Political involvement was there, etc., etc. So many things can be discussed on that particular judgment. In fact, we can have whole 3-hour session on this particular judgment to be discussed, Keshwanand Bharati. There's a total whole on about the amendments to the Constitution. But the only thing which I want to discuss here is that judgment has laid down a very important feature of our constitution. At that point of time, Honorable Supreme Court, with a majority, 7-6 majority, I would say, held that there are some fundamental attributes of our constitution. There are some fundamental aspects which cannot be altered at all, even by any procedure. Like even if you have a special resolution in both the houses, unanimous resolution, you got consent from state, 50%, etc., etc., whatever the things are. Our constitution has some of the special attributes which are called as basic structure of the constitution. These cannot be altered. So they have narrated, at that point of time, they have narrated a couple of features and specifically meant that these are not the only basic features, basic structure of the constitution. There may be any other one which are actually kept on adding by the other judgments of the Supreme Court. If I just introduce a couple of them. First, unity and sovereignty of India. Always united, sovereign country. It cannot be compromised by way of any constitutional amendment. Democratic republic. We are a democratic country. There will not be any compromise on it. Federal structure. We are having two concurrent powers, state as well as union. So this is what a basic structure. Supremacy of the constitution itself. That constitution is a supreme. This is what the fundamental structure, part of the basic structure. Then secular character. That our constitution is a secular. This is a part of basic character. And individuals' freedom. That all the citizens shall be free. These all are the points which were being explained in the Keshwanand Bharati's case, that these form part of basic structure of the case and cannot be compromised by way of any amendment in the constitution. Thereafter also, through different judgments, so many other aspects were being added one by one, like judicial review is being treated as a part of basic structure. Free and fair election, these are also being treated as a basic structure of the part of the basic structure of the Indian Constitution. So this is what all about I just wanted to share or maybe talk upon with regard to basic aspects of the Indian Constitution. Now let me come to something about professional and in relation to taxes. See, when you have a good knowledge of the Constitution, when you run through with the provisions, you get so much confidence whenever you are having your cases before any authority, number one. Number two, in understanding the law itself, many a times we have seen that the particular provisions of act, many a times rules, notifications, circulars were being quashed by the courts. So those were being quashed because they are not in sync with either constitution or maybe the parent law. Reading of the constitution gives so much strength while handling all these cases and understanding of the law. I have a couple of provisions of the constitution which I have in my mind, which we all professionals should deal with, at least go through with all of them. Let us start with Article 20 itself. See, let me read it for all participants. It says Article 20, Clause 1. No person shall be convicted with of any offences except for violation of a law in force at the time of commission of the act, charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. जब लॉ बना था उस टाइम जितनी पेनल्टी या प्रोसिक्यूशन कन्विक्शन प्रोवाइडेड था उससे ज्यादा किसी भी आदमी के ऊपर नहीं डाला जा सकता। एक बेसिक चीज है जो कि हमारे कॉन्स्टिट्यूशन में लिखी हुई है। अभी कैसे इसको यूज कर सकते हैं, क्या बात यूज कर सकते हैं? कई बार ऐसा चीज दिमाग में आती है कि अरे नाउ देयर इज अ चेंज इन पर्टिकुलर लॉ। फॉर एग्जांपल, अंडर द जीएसटी लॉ some requirements are introduced with effect from 1st January 2022. Most debatable issue of input tax credit. That input tax credit shall be eligible when it is getting reflected. I'm using a layman's terms, the technical term is a bit different, but when it is getting reflected in your so-called 2B or 2A. Basically, your vendor has filed a return under section 37 and it has been communicated to you. Some other amendments are being implemented with effect from 1st October 2022. Section 38 amendments are there. Can they have any impact on the past transaction? Can they have? Can authority take a view, okay, now this kind of provision is there, so even for the past transaction, we will not allow you? When I say, can there be any impact? I would say yes, there can be a positive impact on the past transactions. It clearly shows that this kind of provision was not there earlier. And when you read this particular provision in light of Article 20, Clause 1, it clearly says that आप पुराने टाइम के लिए compliance नहीं मांग सकते. So I cannot be penalized if my 2B was not showing those kind of credit earlier. कुछ और इस तरीके के एक बात और देखता हूँ आज की डेट में वापस ये ITC के bogus claims वगैरह के cases बहुत है. I'm sure each and every one of us is having these kind of cases. Let me tell you something. See, Section 132 of the GST Act. Section 132 of the GST Act used to read, whoever commits any of the following offenses. Then there was a list of offenses which started from A, B, C, D, E, F, G till L. So there are a list of offenses. But what they said is, whoever commits any of the following offenses. Please read this particular provision in light of Article 20, Clause 1. And the offenses for which the department makes a case are the offenses that whoever commits these offenses, offense number 1, issue any invoice or bill without supply of goods. Issue any invoice. Number 2, avails input tax credit using that invoice. Now, if I go and in all the cases, for more specifically for the mastermind type of persons who planned whole of the affairs, the department made in all the charge sheet, department has raised these clauses: Clause C, Clause B, and Clause C. Now the question comes, whether that fellow has raised a particular invoice. I'm talking about a person who himself is not registered, but who arranged all this ecosystem of bogus invoices. Who himself is not registered. He got other persons registered. He used that network. Now, whether he issued the invoices, number one, invoices being issued by some other person, neither he issued nor he can issue, because in under section 31, only a person who is registered can only issue the invoice. Similarly, it says avails input tax credit. Who can avail input tax credit? The person who is registered. If I talk about the person who is a mastermind of whole this ecosystem, who is not registered one, has not availed, as he himself has not availed. Yes, he abated or he planned, he designed ecosystem, but he himself has not availed. He himself has not availed input tax credit. But department has made all these cases. When the matters reached up till court and these kind of pleadings were there, government understood that there is some loopholes were there. So government amended the law, and instead of words whoever commits any of the following offenses, they replace the word whoever commits or causes to commit and retains benefit arising out of any of the following offenses. Meaning thereby, when this amendment is there, it will be prospective only. Because in 17, 18, 18, 19, 19, 20, the person who does all this stuff, I'm not taking side of anyone. We are discussing law, how the law should be understood, how law should be read. ये कॉन्स्टिट्यूशन के सिर्फ एक छोटे से आर्टिकल से निकल के आ रहा है, 20 क्लॉज 1 वहां से निकल के आ रहा है. Assuming सब उस मास्टरमाइंड ने, उस पर्सन ने सब कुछ गलत किया, he has developed a ecosystem जहां से कि वो मल्टीपल आपके फॉर्म्स बनी, उनसे कुछ बोगस किया, XYZ, जिसके अगेंस्ट में जो होना है वो सब होगा. बट आई एम टॉकिंग अबाउट दैट पर्सन. There was no provision. If I talk about 132(1) only, he doesn't get covered into it. He gets covered into it only and only after amendment made through Finance Act 2020. Not before that. Which got implemented, if I am not wrong, 1st January 2021. So before that, this provision will not work. There was a residuary clause whereby punishment of 6 months, maximum 6 months was there, or rather is there. Yes, he gets covered into it, not in the earlier. Similarly, if we go to section 122 of the GST law, same situation is there. 122 specifically says, 122 subsection 1. If you read it, it starts with where a taxable person who does this thing. A person who is not registered, neither registered nor liable to be registered cannot be said to be a taxable person. Government gets to know this thing, and again from Finance Act 2020 only, they introduce a new clause 1A in line with the amendment what is done 132(1). So again, in my humble opinion, yes, after that amendment, that person will get covered in 1A, but before that, he cannot be covered into it. So residuary clause, whereby the maximum penalty of 25,000 is there, can be levied. Now let us go a bit further. Some Article 20, Clause 3. No person accused of any offense shall be compelled to be a witness against himself. No person accused of any offense shall be compelled to be a witness against himself. सिर्फ एक लाइन का क्लॉज. अभी आपके किसी भी एक्ट की प्रोसीडिंग्स हो, जीएसटी में होगा, इनकम टैक्स में होगा, और किसी में भी होगा, ये कितना यूज आ सकता है? क्वेश्चन इज कि जब समन दे के बुलाया जाता है एक्स पर्सन को, क्या उसको कंपेल किया जा सकता है ऐसे क्वेश्चंस में कि जो उसके लिए खुद डेट्रीमेंटल? प्राइमा फेसी आंसर अपीयर्स नो by reading this particular point, by reading this particular clause. इसकी भी बहुत डिसेक्शन की जरूरत है. मैं बहुत ब्रीफ में चीजें बता रहा हूं बिकॉज see, now this is using the word accused. Now there will be an argument, I'm sure, जो पार्टिसिपेंट यहां पर सुन रहे हैं, they will say कि अभी तो सम्मन दे के बुलाया ही है, सर, अभी accused नहीं हो गया. For this you will have to refer CPC. This is what I'm sharing my analysis. I may be wrong. Maybe courts will tell us in future what is correct, what is wrong. But this is what my analysis, how I am going on all these kind of stuff. When we go to CPC, which is mandatorily applicable on the summons issued under the tax laws, summons has to be issued as per provisions of Code of Civil Procedures. They say जब summon आप issue कर रहे हैं, when any of the court is issuing any summon, it has to be mentioned that whether this summon, let us assume summon is being given to Mr. X. You come to us, get your tender your statement or produce these document and evidences. For example, this kind of summon is issued to Mr. X. It is duty of the court. In our cases, it is duty of the officer who is issuing summon to mention on the summon that the person, Mr. X, is being called as a witness or as an accused. That means what type of case the department is having. The officer is calling Mr. X for an inquiry against him, against Mr. X, or inquiry is against Mr. Y and Mr. X is being called to give some kind of a statement. It has to be mentioned on the summon itself. And though I must say that in 99% cases, this aspect has not been mentioned. That you are being called for as an summon, as an accused or as a witness. When I am not saying, it is not mentioned and the statement is getting recorded and something is being asked which is detrimental to me, I can safely presume that it is against me. Thereby, I get protection from this. This is what I'm articulating all these things. Next, important one. Nearby, 21. I'm just touching upon some of the articles of the Constitution which are useful for our professionals. It says, Article 21 of the Constitution says, no person shall be deprived of his life or personal liberty except according to procedure established by the law. Most important, very frequently used. Personal liberty is of utmost importance. Courts has regularly held that a premises of a person, any person, this is not even the citizen word is not there in this particular article. They say person. Premises or a residence of a person is like his own castle. जैसे राजा का गढ़ होता है ऐसे वो गढ़ होता है. इसमें कोई दूसरा एंट्री नहीं कर सकता, नहीं करनी चाहिए. Now this article says it cannot be done except according to the procedure established by the law. In all such cases, when we read all these kind of judgments, this article and judgment on this article, we start analyzing when search happened when inspection happened, whether it was as per the procedure prescribed by the law or not. In fact, recently Supreme Court has specifically said that privacy is integral part of Article 21. Privacy. And it is not personal liberty and life, dignified life. It's not just meant that living like a cattle. Dignified life as a human is being treated as a fundamental right. Privacy is being treated as a fundamental right, which a state has to ensure to every person in India, not only on the citizen itself, to every person. Now comes to tax laws. If we talk about 132 income tax or 67 GST law, they specifically says if the respective officer has, if the proper officer, is the authorized relevant officer has reason to believe so and so, so and so, so and so. Different wordings in different laws. Now, whether reason to believe is actually there or not, for the points mentioned there, let us assume GST law says if the officer has reason to believe, officer of the rank of the Joint Commissioner have reason to believe that some records, goods, things, documents are secreted, then only search can be authorized, search and seizure can be authorized. Now you will see so many times the search has happened for classification disputes, for maybe particular goods are exempted or not exempted. Recently, couple of searches last year, so many searches has happened in Jaipur as well for these on these distributors, film distributors. So why? Because they were paying taxes on 12%, but department was of the understanding that there is a tax rate is of 18%. Flour mill, so many flour mill had been searched. Why? Because the assessee was of the opinion that it is exempted. Department was of the opinion that it is taxable at 5% because it is branded, non-branded. Totally interpretational issues. In all these cases, question comes whether the proper officer, whether the authorized officer has recorded the reason to believe in accordance with the legal provisions. I have seen couple of places whereby the person has flown away. Kahin na kahin chala gaya, bhag gaya. And department made search at his home. For what? For searching the person. Where is that fellow? Can search be happen for this reason? My answer is no. Why? It is absolutely illegal in light of Article 21. Recently, Honorable Delhi High Court in case of Harjai Trading Company has observed the same thing. That privacy is enshrined in Article 21 and search is intrusion in privacy of any person. So it has to be only and only with the authorization of law for the purposes for which law authorizes, not otherwise. This is what briefly I wanted to share something about Article 21. If we proceed further on Article 245, that's again a very interesting section. Extent of the laws made by the parliament and the state legislatures. See, Article 245 says that the parliament and the legislature of a state may make laws for the whole of their territory. And as per Schedule 7. So we are having Schedule 7, which is having 3 lists: union list, state list, and concurrent list. One question, see, when we go through with this particular provision, or rather before, and then we see what kind of the transaction or maybe issues are before us, probably we can make up a better opinion. I'll give you a simple question. Let us see a person sitting in India purchases something from Australia and directly sells to UAE. Can there be any tax implication on him? Can there be any tax implication? Maybe. When we don't refer to the constitutional provisions, we may say directly that, okay, when no leg of the transaction is there in India, how come Indian government can make any law? See, I'm not talking about whether there is levy or not. What I'm talking about is, can there be any levy or not? That means whether a constitution authorizes or not. Maybe I have discussed this aspect when in 2017-18, when this GST law was introduced. So many of us had the opinion that no law can be made for these type of transactions. Then I had a second thought. Let us assume I'm a service provider instead of supplier of goods. And I'm taking those supplies from Australia. I'm taking some order from Australia, subletted to the UAE, and the UAE guy is performing everything. I'm not involved in anything. Can there be any levy? सभी के आंसर चेंज हो जाते थे. Yes, now there can be levy. Let us read Article 245, Clause 2. No law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operations. Clearly लिखा हुआ है. Some nexus, अब nexus person is here. Nexus is enough. This nexus is enough to grant authority to the union to make the law. To grant authority to Parliament. Whether there is any levy or not, I am not discussing it. Can there be? And this aspect has been recently discussed by the Honorable Supreme Court in Mohit Mingal's case. Again, there was a similar type of issue was there framed up and came up before the Supreme Court in Mohit Mingal's. What happened? The argument was that shipping company sitting outside India is in contract with a supplier who is outside India. So both the persons are outside India. So let us say goods are coming from UK to India, and UK supplier has entered into a contract with a shipping company of Singapore so that the goods can be delivered to India. So the contract is between UK supplier and the Singaporean shipping company. India is not at all involved. How much is the freight? Indian party doesn't know, India doesn't know. So can there be any, can government of India, can Parliament make a law to tax that transaction? So Honorable Supreme Court has specifically discussed this article and says that no law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. And in this transaction, the nexus is direct, that the goods are coming to India. By virtue of that contract, goods are coming to India. So precisely, when we read all this particular aspect, probably we are in a situation, we are in a position to understand the legal provisions better. If I come to Article 246, commonly known as division of powers between union and states, though actually it is not like that. कई बार क्या होता है, हम लोग देखते हैं स्टेट लिस्ट में, यूनियन लिस्ट में कोई चीज है, okay, this particular entry is there in the union list or a state list, and state government has let's say imposed some tax, and we are going to see, okay, whether the state government is competent or not. Fair enough. What happened with union? Let us say union government has levied a particular law, has came up with a particular law. Whether the same analogy will apply? Answer is no. See, these list, union list, state list, and concurrent list. Concurrent is different in such a sense that concurrent list doesn't have any taxing entries. Union list and state list are having a firstly administrative entry, thereafter taxation entry. Both union and state list, like in union list, entry number 1 to 81 is administration entries. Thereafter, there are tax entries. Similarly, in case of state is also the same story, same architecture of the provisions are there. So what happens, whether these are the powers which are given in the states, in these lists? Answer is no. It has been categorically held in multiple cases. These are the fields of legislation, not power. Power are coming from Article 245, 246, not by the list per se. And if any matter is not covered by the state list, in that case, union government has full right to make the law. Please refer Article 246, Clause 4. It says Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is matter enumerated in a state list. Then Article 248, subject to Article 246A, Parliament has exclusive powers to make any law with respect to any matter not enumerated in the concurrent list or a state list. So central government can definitely and certainly makes the law, even if that particular aspect is not there in the union list, subject to the condition that it should not be there in the state list, whereby the state has a prominence. I'm just having a thought in my mind when I'm just discussing these kind of lists. कई बार discussion और बातचीत में आता है, oh, agriculturists, they are not being taxed. Many a time we see when we are sitting in some discussions, people say, no, so many people are earning so much in the agriculture, more specifically in areas like Punjab, Haryana. Very fertile lands are there, and these people are super rich. They should be taxed. So agriculture income को जो exemption है वो कहाँ पर है, कहाँ दिया हुआ है exemption में? जब इनकम टैक्स एक्ट जाके देखते हैं तो देयर इज अ सेक्शन 10 which says this agriculture income के ऊपर टैक्स नहीं हुआ something. क्या एग्रीकल्चर इनकम के ऊपर यूनियन गवर्नमेंट टैक्स लगा भी सकती है? क्या ये कैपेबिलिटीज, क्या ये पावर्स हैं यूनियन गवर्नमेंट के पास? आंसर इज नो. For the simple reason, if you go to the entry 82 of the union list, it clearly says taxes on income other than agriculture income. And taxes on agriculture income are covered by entry 46 of the state list. So जब ये वाली चीज देखते हैं तो ये दिमाग में सीधा सीधा आ जाता है कि levy of income tax by the union government on agriculture, ये कोई discussion का point ही नहीं होना चाहिए. This is a futile discussion if we are discussing it from the union government point of We'll take up maybe one or two more particular aspect, maybe 265. So the birthplace hai. No tax shall be levied or collected otherwise than by way of authority of law. No tax shall be levied or collected. Very, very important one. We all are dealing tax matters. Any tax law can be promulgated by the government once it is authorized, not otherwise. Like we have discussed state list, central list. Now we have a special entry 246A for GST. See, levy is like it has to be authorized, so fine. An important aspect which I want to discuss here is collection. No tax can be collected except by way of authority of law. अभी जब अपने पास कितने भी cases आते हैं, when we are dealing like scrutiny issues, audit, inspection, search and seizure. Now what happened? Crux of all the inquiries are, you deposit the money. That's it. You deposit the money, chapter ends. This is what a mandate behind all the inquiry proceeding, चाहे वो audit है, चाहे scrutiny है, चाहे search and seizure है. और हर जगह देखा जाता है, खास तौर से सर्च वगैरह में, कि ऑलमोस्ट गन पॉइंट के ऊपर अमाउंट डिपॉजिट कराया जाता है. वी ऑल नो दिस. आप कितना भी ज्ञान दे लो, कुछ भी कर लो, जब भी सर्च होती है तो वो सर्च को जो आदमी वहां बैठा है वो उस टाइम पे कहता है नहीं जी मैं जाऊंगा ही नहीं जब तक इतना पैसा डिपॉजिट नहीं हो जाए, नहीं तो 50 चीज और निकालूंगा. इज इट राइट? इज इट लीगल? क्या ये बिहेवियर उन ऑफिसर्स का करेक्ट है? आज खास तौर से आज के दिन कॉन्स्टिट्यूशन डे के ऊपर हमें ये सोचना चाहिए, ये डिपार्टमेंट ऑफिसर्स को दिमाग में डालना चाहिए, क्या ये बिहेवियर उनका हमारे कॉन्स्टिट्यूशन के हिसाब से करेक्ट है? आंसर इज एब्सोल्युटली नो. दिस इज नॉट ऑथराइज्ड बाय लॉ. लीगल प्रोविजन जो लॉ में है, जीएसटी लॉ की अगर मैं बात करता हूं तो वहां पर स्पेसिफिकली दिया हुआ है, जब आपका डिमांड निकल के आ जाती है, ऑर्डर पास हो जाता है, उसके 3 महीने तक का टाइम है आपके पास, तब तक आपको अमाउंट डिपॉजिट कराना है. नॉट बिफोर दैट, नॉट इवन ऑन इश्यू ऑफ द शो कॉज नोटिस. यू हैव एन ऑप्शन टू पे, बट आपको जो मैंडेटरी रिक्वायरमेंट है लॉ की, उसके लिए आपको ऑर्डर पास होने के बाद 3 महीने तक का टाइम है, और यू मे फाइल द अपील इन बिटवीन विद प्री डिपॉजिट. दैट्स इट. नो वन कैन फोर्स यू, बट इन ऑल प्रैक्टिकल सर्कमस्टेंसेस फोर्स करके पैसा जमा कराया जाता है. अभी बहुत सारे जजमेंट्स इस चीज को लेके जीएसटी लॉ के अंडर में खास तौर से आए हैं, विद एन स्पेशल एम्फेसाइज. See what happens when all these matters reached court. एक ही चीज डिपार्टमेंट के सामने कोर्ट, डिपार्टमेंट की तरफ से एक ही प्लीडिंग आती है. ईच एंड एवरी केस that we have not used any force, assessee paid these amount voluntarily. वो जो फॉर्म डिपॉजिट कराते हैं उसमें वॉलंटरी का टिक भी कर लेते हैं, लाइक वो 73.5 और 74.5, मोर इन ऑल द केसेस 74.5. 73 क्यों कराएंगे सर्च? So now the point is, when it is a voluntary deposit, whether the government has locus to retain that amount. Let us assume the department says that amount has been deposited on a voluntary basis during inspection proceedings. Assessee says after that, the moment search concluded, assessee raised its objection or retracted that okay, it was not a voluntary one. Under pressure, it was deposited. what gonna happen? A very key aspect which is to be noted that under GST law, there is no provision of advanced taxes. Advanced taxes कोई provision ही नहीं. So जब advanced tax का provision ही नहीं है तो and assessees retract, no, it was not voluntary. Whether department has any locus to retain that amount? My humble opinion answer is no. In deemed distributor's case, Honorable Division Bench of the Karnataka High Court dealt this issue brilliantly. They have specifically referred Article 265, read with Article 300A, right to property given by the Constitution, that no person shall be deprived with of his property otherwise than by way of authority of law. So law doesn't provide you authority to take his property, to retain his property, because tax, he's saying it is not self-assessment. He's saying it is not paid by him voluntary. So you cannot retain it. So under article, referring Article 265, Article 300 here, Honorable Karnataka High Court has specifically held. So many other cases are there on the same line that you cannot retain this amount. This amount has to be refunded to the assessee. You may issue the show cause notice. Proceedings may go on. The assessee has its own right to file the appeal and other aspects and may go ahead in that. One last point on Article 265 itself. Many a time we see that there are we talk about refund. Let us say by whatsoever reason wrong tax has been paid, excess amount has been paid. Is there any specific provision which allows you to give the refund, the excess payment of the taxes, which authorizes that okay, excess, if in these circumstances you can claim the refund? There may be n number of cases, no? Maybe some misreport in a particular year, 3B में कुछ ज़्यादा डाल दिया, maybe और किसी reason से कोई accounting error हुआ, कुछ ज़्यादा चला गया, आप वो हम technical issues में ढूंढते रहते हैं, but broadly, ultimately, if some excess tax is there, क्या GST law में ऐसा कोई provision है which authorizes you to claim the refund, which authorizes you to have the refund? My answer is no. There is no such provision. Though there is a provision for prescribing the procedure to claim the refund. If you go to section 54, please have a careful reading. Section 54 says any person claiming refund of any taxes and interest, if any, paid on such tax or any other amount paid by him may make an application before the expiry of 2 years from the relevant date in such form and manner as we prescribe. What is saying? Any person claiming the refund. So when will you claim the refund? When you have paid excess tax. So in that case, you have to see that actually Article 265 is authorizing you. The right originates from there. Why? Because government can levy and collect the taxes which are authorized by the law. Let us say, let us assume a person has paid taxes on supplies of 2 crore, whereby actual supplies were 1 crore 50 lakh rupees. So he has actually paid more tax on 50 lakh rupees, which was actually not a supply. So he can very well claim maybe one kind of mistake or another kind of mistake. In each and every case, he can file the refund. He has to justify his claim. He has to explain that the claim was bona fide, genuine, and this kind of mistake was there. He may file the application. Why so? Because 265 authorizes. Government cannot retain this money, cannot hold this money. These were some of a couple of things which was in my mind. कि भाई कैसे किस तरीके से कुछ important aspect जो I wanted to discuss with you. Yes, one more aspect for. See, हम लोग जब भी law में पढ़ते हैं, कोई भी act देखते हैं, तो we see that there are marginal notes. That means some heading of the section is there. We try to take meaning from this. Yes, correct. It gives an idea कि context में क्या लिखा है. Similarly, when you go to the Constitution, कॉन्स्टिट्यूशन में भी मार्जिनल हेडिंग से, दैट मींस सेक्शन का जो मार्जिन नोट हेडिंग है वो आपको बताता है कि इस पर्टिकुलर क्लॉज में क्या लिखा हुआ है, इस पर्टिकुलर आर्टिकल में क्या लिखा हुआ है. दैट गिव्स एन फेयर आइडिया. साथ साथ में एक बहुत गाइडिंग फोर्स जो हमें देता है, दैट्स अ प्रियम्बल टू द कॉन्स्टिट्यूशन, जो कि बहुत एलोबरेटली लिखा गया है, जो बेसिक ऑब्जेक्ट्स बताता है कि इस डायरेक्शन में इस तरीके से हमको रन होना है, इस तरीके से हमें चलना है आगे. वन मोर इंटरेस्टिंग फैक्ट, in fact yesterday only when I was in high court, I was examining high court में अभी जो ओरिजिनल कॉन्स्टिट्यूशंस की कॉपीज लगाई हुई हैं कि देखने के लिए कैसे कैसे वो बना हुआ है. So it was there yesterday. I was just going through with it. A very interesting thing which I observed was, see, there are different parts of the constitution, that all the articles are divided originally into 22 parts, which were extended, and 25 parts are there as of now after multiple amendments. When on start of each and every part there is a symbol. There is a symbol which gives a hint, or which gives a theme or thought process behind how and for what purposes it is being there, after what was there in the minds of the law, these draftsmen of the constitution. For example, part 1, which talks about the Union of India and its territory. The symbol there is a bull with a hump. If you go to part 1, so that it starts with a symbol of bull with a hump. What it signifies, what's the theme in it? Precisely, the bull with a hump is a sign or symbol of the Mohenjo-daros, of the Indus Valley times. So that means somehow the lawmakers or the constitution makers wanted to tell that it is not a new country which is going into existence, which is coming into existence. No, it's not a new country. We are having old civilization. It's not at all a new nation. Similarly, if we go to the most important, or I would say favorite part of the Constitution, part 3, fundamental rights. At least for lawyers, it is the most important part of the Constitution. The picture depicted is of Lord Ram, Lakshman and Sita in part 3. So what is thought? Prima facie, it is like a constitution makers wanted that our country should run like a, जैसे राम के वो राम राज्य वर्ड यूज करते हैं. तो थॉट प्रोसेस वाज कि जो भी हमारे सिटीजन्स हैं उन सबको ये राइट्स अवेलेबल हो जो कि एक राम राज्य की तरीके से स्थापना में सहयोग करें. If you go to the part 4, directive principles of the state policy, though not cannot be used by the citizens, but it is directive principle for the government that on this line the policy should be. There the picture is of Lord Krishna and Arjun. वो जो महाभारत वाला सीन है वो पिक्चर वहां पर डिपिक्ट किया गया. यानी कि आपके जो ऑब्जेक्टिव्स हैं वो आपके क्लियर होने चाहिए. जैसे कि कृष्ण भगवान ने ऑब्जेक्टिव्स उनको बताए थे, उस तरीके के ऑब्जेक्टिव्स. लास्ट जस्ट व्हाट वी कैन रिकलेक्ट फॉर आवर फाइनेंस एंड और प्रॉपर्टी, जो हम आर्टिकल 265 वगैरह सारी चीजें देखते हैं, 300A की भी अगर मैं बात करूं तो. सो वहां पर बेसिकली क्या है कि वहां पर जो दो पिक्चर डिपिक्ट की गई है, नॉट ओनली वन. पार्ट 12 ऑफ द कॉन्स्टिट्यूशन, दो चीजें. वन, एक स्वास्तिक का निशान जो हम सब लोग घरों में और सब पूजा स्थल के ऊपर जो बनाया जाता है. द अनदर इज ऑफ नटराज, वो डांस करता हुआ जो एक गोल मूर्ति रहता है, नटराज वाला. सो प्रिसाइजली व्हाट हैपेंस, स्वास्तिक इज अ ऑस्पिशियस साइन and Nataraj shows financial stability. So basically ये सारी चीजें का एक थीम बताता है. जो मैंने जैसे राम का आपको फोटो बताया, लॉर्ड राम का, राम लक्ष्मण सीता का पार्ट 3 में फोटो दिया हुआ है. That in fact was used by the court also, and by virtue referring to those statutes, the Lord Rama, this is वो राम जन्मभूमि केस जिसमें था, उसमें उनको एक constitutional entity माना गया. So apart from marginal notes, we are having a elaborate preamble to our constitution. Then we are having these pictures which are deposited at the initiation, at the entry, start point of any of the part of the constitution, which gives a fair hint that what was there in the minds of, in the brains of constitution makers. I think with this, I should I'm can close my session. If any queries are there, I'm happy to answer. And I also thank JCAG and whole of the team of JCAG for giving me this opportunity so that I could discuss some of my thoughts on the constitutional aspects. Thank you very much.
Thank you, Jatin. We are requesting every participant to kindly on your camera. And if any query, kindly raise your hand or share in chat box.
Akshay, it will be difficult for me to read. मैं mobile से address कर रहा हूँ अभी.
So participant can share me. So I got one query written there. Right to privacy is treated as fundamental right, but what is really meant by privacy? It is against society or against other individual or against digital privacy or against government. How far should we read it in the light of constitution?
मेरे को आवाज बहुत धीमे आ रही है आपकी. अक्षत, what I understood, let me tell you, you are asking for privacy. What do you mean by privacy? Correct? Is it the question?
Yes, sir. Yes, sir.
Okay. So privacy, what I discussed in light of Article 21 was in respect of a search case. So when I'm talking of privacy, I'm talking about a person on which search action has been initiated. So when you are sleeping in your home, at 7 o'clock, 8 o'clock, someone knocks. It should be your will whether you want to open it or not. ये आपका घर है. आपकी मर्जी के बिना घर में किसी की एंट्री अलाउड नहीं है. This is what basic understanding. Just like इंडिया की टेरिटरी में कोई भी बाहर का आदमी बिना वीजा परमिटेड नहीं है. इंडिया ने एक पॉलिसी बना रखी है कि उस तरीके से आप एंटर करो. सो दैट इज द करेक्ट वे. सो इसी तरीके से आपके घर की एक पॉलिसी है, नो, आई डोंट वांट टू एंटरटेन एनीवन बिफोर 9. सो दैट काइंड ऑफ प्राइवेसी इज गिवन टू यू बाय आर्टिकल 21, which can be breached only by a legal process. That this is what I meant. Hope your query is answered.
Right. Thank you. Is any other query? No other query there. Thank you, Jatin, for the wonderful deliberation. It is just like 360-degree comparison, starting from history, international comparison, minimum rights, and different articles. And I hope participants को बहुत अच्छे समझ आया होगा. So thank you very much. Thank you very much, JCG members, non-JCG members, our chairman Jatin sir, and Gesh Bhaiya for the wonderful initiation. Thanks a lot. Thank you. So Gesh Bhaiya, you can brief if any other point. I think he's in traveling mode. So thank you everyone. Thank you very much. Have a nice day.
Thank you.